We also note that this webinar is being recorded and will be distributed later. So do bear that in mind in terms of anything that you may wish to contribute through that question and answer function. But without further ado from me, I'll hand over to Dan, who will be addressing indirect discrimination. Thanks, Dan.
Thanks very much, Alice, and thanks very much, everybody, to attending. As Alice said, I'm going to be talking about indirect discrimination against tenants and potential tenants. Although, in fact, I think in the end, I'm primarily going to focus on tenants and, I mean, particularly how indirect discrimination might be used as a defence in possession claims, particularly. So, just by way of introduction, the point of my talk, if you want. As you'll all be very familiar with, in the 10 years since the Equality Act came into force, defences to possession claims based on disability discrimination under Section 15 have become very well established. So there was, of course, the Supreme Court decision in Acomb and Livingston, and then that was cemented really in Stevenson by the Court of Appeal with a very helpful description of how that defence might work in practice. Similarly, we've seen a number of cases where the public sector equality duty has been considered in the context of possession claims, albeit probably slightly less powerfully now, I think, as a defence for tenants than Section 15. So cases like Norton, Forward, and Dodana. But what it seemed to me when I first was thinking about this talk and has been borne out in my preparation is that actually there's surprisingly limited authority, it seems, on indirect discrimination as an argument in the housing context. And I'll come in a moment to review some of the cases that have been brought, but it's certainly not that that nobody's running these arguments at all. I obviously know from my own experience and from speaking to colleagues that the defences, for example, are being run on the basis of indirect discrimination. But because there aren't any reported cases, or even, in fact, I had a trawl through the back issues of the Legal Action magazine housing updates, there aren't even many decisions that have been reported to that level, let alone binding authority. And so in that context where people are running some defences, but there isn't really that much out there in terms of reports, it seems to me to be even more useful potentially to have a session like this where people can share their experiences, share their questions, so there's some kind of exchange between practitioners. And so with that in mind, and those most famous last words from Barrister, I'm going to aim to be relatively quick on this, about 15 minutes, if that, just really to kind of have a quick skim through as a recap of the principles relating to indirect discrimination, followed by a very quick review of where it seemed to me we've got to so far with cases, and then just to pick a couple of themes, a couple of scenarios where indirect discrimination arguments might be of relevance. So starting out then with just a very lightning recap of indirect discrimination. Section 19 of the Equality Act provides that where A applies a provision, criterion or practice, referred to as PCP, to B, and A applies or would apply the same PCP to people without B's protected characteristic. 3, that PCP puts or would put those who share B's protected characteristic at a particular disadvantage when compared to those who do not share the protected characteristic. 4, the PCP puts or would put B at that disadvantage. And 5, A can't show that the PCP is a proportionate means of achieving a legitimate aim. Then in those circumstances, in the spheres to which the Act applies, that will constitute unlawful indirect discrimination. And so just drilling down in a little bit more detail into some of those elements of the definition. PCP, I should say, in fact, you'll see there's a number of references in the slides to what I've called the EHRC SPFA code, which is the Services, Public Functions and Associations Code of Practice, which is a statutory code of practice. And to date, there still isn't a code of practice relating to Part 4 of the Act on Premises. And so it can be helpful to look at the Services, Public Functions and Associations Code in the absence of any guidance directly on premises. So the code says that PCP is to be construed widely to include any formal or informal policies, rules, practices, etc. But it's important to note the recent case of Ishola and Transport for London, which said although a PCP can be a one-off decision, that doesn't mean that any one-off decision will automatically be a PCP. And the dividing line is that the decision has to reflect the way that things would generally be done. So if it's truly one-off and it's not indicative of a position more generally, then the case might fall short on that requirement. So A applies it both to those who share the protected characteristic and those who don't, relatively self-explanatory. Perhaps the most difficult stage is that it puts or would put those who share the protected characteristic at a particular disadvantage when compared to those who don't share the protected characteristic. And so that requires the identification of a pool for comparison, and that should generally be the pool of all of those affected by the PCP. So if there's a policy in place, it might apply to all tenants, whether or not they have a disability. And when looking at that, there has to be no material difference in the circumstances of those with and without the protected characteristic in relation to whom you're trying to show indirect discrimination or disparate effect. It's important to note that the comparator can be hypothetical because the definition is that A applies or would apply the same PCP to those without the protected characteristic. And then also in relation to disadvantage, it's always important to think about whether you might need, what evidence you might need to show that people with a protected characteristic are put at particular disadvantage. And what the EHRC code says is that in some cases, the fact that it will disadvantage people with a protected characteristic may be obvious. So, for example, a very obvious example, which I'll come to later, is that a practice which disadvantages victims of domestic violence will almost inevitably put women at a particular disadvantage as compared with men, because women are disproportionately victims of domestic violence. So there are some areas like that where it's going to be quite clear, but in other cases, it may be necessary to get statistical or expert evidence to try to demonstrate that, because although there are cases where the courts take judicial notice of particular facts, like women being disproportionately victims of domestic violence, that's not always going to be the case. And so you have to think whether you'll be able to demonstrate that. Finally, in relation to proportionate means of achieving a legitimate aim, just as a recap, you've got to identify, or rather A has to identify, because the burden is on the discriminator, has to identify a legitimate aim, that there's a rational connection between that aim and the PCP, that the PCP is the least drastic means of achieving the aim, and that in all of the circumstances it's proportionate. So as I've said, the burden's on A, and it's a question for the court whether or not it's justified. It's not limited to judicial review type principles of A's decision, but it's important to remember, as the kind of flip side of that, that the justification doesn't have to be justification to which A turned their mind at the time of making the decision, putting the PCP in place. It's open to introduce new evidence as to why it's justified that post-dates the allegation of discrimination. Although, having said that, the EHRC code is quite helpful in saying that where the landlord's a public body, compliance with the public sector equality duty is likely to be a significant factor in whether or not the body is able to justify any disparate impact. So then just a quick recap there about the spheres in which the prohibitions on discrimination apply. So here the primary relevant sphere is premises, of course, under Part 4. Worth noting that Part 4 doesn't apply to age or to marriage and civil partnership discrimination. And so, yeah, even if you identify some disparate impact in relation to those characteristics, that's not going to help you in Part 4. Some various other exclusions. One to note, in Schedule 5, there are exceptions in relation effectively to living landlords. And the final thing is that other matters, for example, allocations policies, which don't fall within premises, might well fall within Part 3, which is services and public functions. So looking so far, the main area in which there seem to have been any indirect discrimination arguments which have made it to reported judgment is in the area of allocations. So I've listed there's a number of cases in which policies were either found to be unlawfully indirectly discriminatory on grounds such as sex or disability. Particularly, I mean, there've been a number of cases regarding residence requirements, those discriminating against travellers and non-UK nationals in Ward and Gulu. And then other requirements such as additional priority for working households in circumstances where women have greater responsibility for childcare and so are less likely to be, or more likely not to be working. And then the other area of the kind of potential tenants section, which is worth mentioning. Again, these are cases under Part 3, so services and public functions rather than premises, are a couple of recent cases that have been run by Shelter, I think under their strategic litigation team, in relation to what have been called no DSS policies, slightly outdated language, where estate agents have had a policy of not accepting tenants who are on housing benefit. And those in 2 county court decisions were held to indirectly discriminate against both women and disabled people who are more likely to be dependent on benefits. So that's really the main area where cases have emerged. So far in relation to Part 4, more or less the sum total of what I've managed to find, and maybe that I've missed 1 or 2 here and there, but it seems we've got a single case on reasonable adjustments, but also upheld on an indirect discrimination ground, which is Plummer and Royal Herbert, and that was a club with premises where there was a policy of never making adjustments to club premises that didn't benefit all members, and so that discriminated against disabled members because effectively those adjustments would never be made. And then there are really a handful, 3 I think, arguments that were raised in possession claims of indirect discrimination on grounds of disability. But those, I mean, those are the case of Davies, Turner and Forward, but in each of those cases, in fact, indirect discrimination wasn't really the central thrust of the case, at least by the time it reached the higher courts. And so we're left with very little discussion of how that might apply. So then moving to consider where next, and as I say, there's 3 areas that I've highlighted. The first is in relation to indirect discrimination on grounds of disability. And as I've said, where evictions being sought on a ground arising in consequence of disability, Section 15 is going to cover that territory. So where you've got a tenant whose disability means that they're less able to manage their rent account and so got into rent arrears, or where you've got somebody like in the Stevenson case where mental health problems lead to antisocial behaviour, then you're looking at Section 15, and I don't think really that indirect discrimination is likely to add very much. However, where eviction sought on a ground that's not directly related to disability in a causal sense, but eviction will have a particular impact because of the disability, I suggest that there might, in the right circumstances, be an argument for indirect discrimination, together perhaps with reasonable adjustments. And I should stress that I think it's important, particularly in the absence of authority, that these cases are very carefully run. And I certainly wouldn't advocate indirect discrimination being thrown into defences as a matter of course. It will only really be in certain cases where it's appropriate. But for example, one case that I had was a successor to a young woman who succeeded to her mother's tenancy, and she was under occupying the property. So the local authority had a ground for possession under ground 15A, where they could provide alternative accommodation, which she wouldn't be under occupying, and she'd have to give up the property to which she'd succeeded. And in that case, the tenant had very significant mental health needs, and crucially, those needs were connected to the occupation of the particular property. So there was a psychiatric report which had diagnosed her with an attachment disorder, which meant that she experienced the attachment to that particular property where she lived with her mother much more strongly than somebody who didn't have an attachment disorder. And so in that case, we argued that a practice effectively of always seeking possession under ground 15A where there was under occupation would put people with an attachment disorder related to the property in that way at a particular disadvantage as compared with people who just experienced the normal sense of attachment to a property where they'd been living. And that was, we got to trial on that, and in fact, the local authority conceded halfway through the trial. But it seems to me that those are the kinds of cases where you might be successful on indirect discrimination. But I've compared there, for example, the cases which have been decided primarily under Article 8, where there was no succession at all, so there was no right to a tenancy, and defences were pleaded on the basis that those left in the property who hadn't succeeded were disabled, but the disability didn't relate to it wasn't relevant to the particular property. So the case of Turner that I mentioned, and also Holly and Hillingdon, and those cases, albeit that Article 8 perhaps doesn't provide the same level of protection, those illustrate why it's important to be cautious about these arguments, because those didn't find favour with the courts. I've also suggested that potentially, although again this is taking the difficulty up one step, there might be cases in which even where there's no right of occupation, where unless alternative accommodation were provided, that there might be indirect discrimination, because the effects of a blanket practice of seeking possession in those circumstances would impact more severely on disabled people. And there's a suggestion to that effect in the context of the public sector equality duty case of Norton. So, for example, it's worth noting in Turner and Enfield, where there was an unsuccessful argument that Turner should stay in the particular property. That was already in a context where the local authority had said, well, of course, we will provide alternative accommodation. So the second area in which I thought there's potential for indirect discrimination arguments is in relation to welfare benefits issues. As I said, in relation to the no DSS cases, at a very general level, women and disabled people are much more likely to be dependent on welfare benefits, including housing benefit. And that's clear from the Office for National Statistics that are published in great detail on all of this. And in fact, if you look at the order in the first of the no DSS cases that I've put a link to, the order has a long record of the reasons for the decision, and that sets out quite a lot of the detail in relation to those statistics. More specifically, that's the kind of very general level, is that people are more likely to be dependent on benefits. But more specifically, there have been the strategic challenges to both the benefit cap and the bedroom tax, both of which accepted that those measures disproportionately affected women in the case of the benefit cap, and bedroom tax there were a number of groups, but including, for example, disabled people who were under occupying and adapted property. But in both those cases, the court held that the policy at a systemic level was justified, i.e. that the government was entitled to bring in the benefit cap or the bedroom tax. And that justification was, at least in part, the court said, because of the availability of discretionary housing payments. So they said it's a legitimate choice of the government to introduce a measure that cuts people's benefits and will disproportionately do that to women or to disabled people, say. But that gap, it's appropriate to leave that gap to be covered by discretionary housing payments. But those decisions about the systemic level don't mean that it will be justified for individuals to suffer the negative consequences of those measures. So, for example, if you have an individual female tenant who is affected by the benefit cap, and of course as a woman is disproportionately likely to be affected by the benefit cap, and that leads to rent arrears, and then the landlord seeks possession, then on the face of it, you may have, if the landlord's practice is to seek possession regardless of the fact that arrears are caused by the benefit cap, then there's arguably a prima facie indirect sex discrimination, which the landlord then has to justify. And of course, it may be open to the landlord to justify that in the circumstances, and it may not. But the fact that these aspects of the system will disproportionately affect particular groups opens the door to at least requiring the local authority to, or non-local authority landlord to justify those decisions. And I suggested that that's particularly the case where the landlord is the local authority that's refused the DHP, and or, for example, where the landlord is a local authority accommodating under the homelessness provisions in Part 7 of the Housing Act, and so is statutorily restricted to charging a reasonable amount. And there's a case of Lucchini and Southwark, which says that that reasonable amount may be nothing. And so in one example, I had a client who was benefit capped and being charged a huge amount a week per rent in very expensive temporary accommodation. And we argued that in those circumstances, given that the benefit cap was applied to her, which she was more likely to suffer that disadvantage than a male tenant, then combined with the fact that the local authority was required to set a reasonable amount, that the decision to pursue these arrears was indirect discrimination, and in the end that resulted in, I think, around £30,000 worth of rent arrears being written off. And I suggested at the end, I mean, this is again kind of stepping up to the next level of difficulty. I focused there particularly on the benefit cap and the bedroom tax, these specific measures that have effects. But given the general statistics about who's more likely to be dependent on benefits, there may even be an argument where you have arrears that are solely caused by chronic delays in the benefit system. Then, of course, women and disabled people are more likely to be affected by those chronic delays in the system. And so particularly combined with the pre-action protocol, which says that where benefits issues are resolvable and will clear the arrears, then landlords should refrain from possession. Then you might have a strong argument to say, well, look, this is discriminatory and it is not justified, given that this is effectively somebody who's just being affected by the delays in the benefit system. So finally, and I realise I'm running out of my self-imposed deadline, I mentioned earlier that obviously it's kind of fairly well documented that women are much more likely to be the victims of domestic abuse, and primarily victims of male perpetrators. So, for example, see Baroness Hale in the Carmichael decision. And therefore, there are a number of types of situation where that might give rise to a disparate impact of a PCP on women. So, for example, where a landlord seeks to evict a female tenant for the criminal behaviour of her coercive ex-partner, that might be if no allowance is made in the landlord's policies, then that might be something which puts women who are more likely to be victims of coercive abuse at a disparate or a particular disadvantage compared to men who are less likely. Similarly, rent arrears as a result of financial abuse, or where there's a relationship breakdown and the landlord accepts surrender or short notice from an abusive ex-partner, again, you might have an argument. Conversely, almost, I've said, where a victim of domestic violence is male, perhaps, or LGBT victim, there is evidence to suggest that actually, on the whole, provision for victims other than female victims of male domestic violence, provision is often lacking, and there are particular issues that arise that might not be well catered for in service provision. And so if you have a landlord that has a policy but doesn't address some of these issues, and you are advising a male or LGBT victim of domestic violence, there may be issues that arise, and an indirect discrimination angle might be worth thinking about. Finally, then, my final slide is just to flag up the fact that where the 2010 Act can't help, for example, because discrimination's on grounds of age or marriage, which is excluded from Part 4, or it's on the basis of a status which isn't a protected characteristic. Article 14, the jurisprudence on Article 14 does recognise also a concept of indirect discrimination, so see DH in the Czech Republic. But as I've said, it's only available where your landlord's a public authority within Section 6 of the Human Rights Act, and it's only available where the matter falls within the ambit of another convention right. But I think, having a look at the time, I should probably hand over at this stage to John, and then we'll come back, I think, at the end to answer any questions that people might have. Thanks very much. I'll just stop sharing my screen if I can.
John, you're currently muted.
Thanks, yeah. Okay, just let me go back to the top. Okay, you see that? Yeah, okay. Thank you, Dan, thank you, Alice, and thank you, Jim. I'm going to talk about liability of landlords for harassment and victimisation. And I think it's really just to be stated, the Equality Act, it's a fantastic statute that wove together and put on one common foundation a patchwork of matters that had grown up over many years, you know, right since the right throughout the 70s in particular. So it's right that we have these seminars, and I think to burrow and delve into areas which perhaps within the specialism of housing haven't actually perhaps been explored or pushed out, maybe as insofar as they might be. Let's just go back to the statutory provision of harassment then. Under section 26 is where we want to look at. A person harasses another B if A, engages in unwanted conduct relevant to a protected characteristic, and the conduct has the purpose or effect of violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. And it's probably right to say that much of the case law historically has grown up and been argued up and down the courts, and to the ECJ, for example, and back down again previously under things such as associative discrimination, has been within the context of employment. And so to actually look at unwanted conduct, for example, in an employment context, you'd be reaching for examples of unwanted conduct which may fall into a harassing type of scenario. So any internal organisation, whether it's a chambers or a law firm, for example, will have a plethora of examples given in the best practice scenario. So there's a statutory flaw with the legal definition, but how that's informed and indeed what the circumstances of the case, just looking at the second bit of section 26. There's the harassment on the grounds of unwanted sexual nature, and then also there's a rejection or submission to such conduct. But going through to 4, in deciding whether the conduct has the effect in subsection 1b, then they must take account, each must take account the perception of the individual, the circumstances of the case, and whether it's reasonable for the conduct to have that effect. Relevant protected characteristics: age, disability, gender reassignment, race, religion or belief, sex and sexual orientation. Section 1, of course, not yet in force in relation to socioeconomic background. That's picked up elsewhere in an interesting seminar that's been run within Doughty Street as well, in the general series that Chambers is running. It's interesting, just having prepped for the seminar, that the issue of sexual orientation, religion and belief is out with certain provisions, and I'll come on to that in due course. Victimisation, and again, it's a separate and distinct aspect within the Act. Victimises A, victimises B if they're subject to a detriment. If B does a protected act or believes he has done so, B has done or may do a protected act, and then setting out the protected acts, bringing proceedings, giving evidence in connection or information in connection with proceedings, doing anything other than the purposes or in connection with this act, making an allegation, whether express or not, that A or another person has contravened the Equality Act, and or indeed the victimisation rule. And it's, without wanting to generalise too much, certainly in a previous life as a trade union caseworker, looking at victimisation, looking at a long tranche of documentation, victimisation, I would say, and again, it's not, don't want to generalise, it's easier to spot, I would say. It's almost like things chug along and then somebody makes a complaint, or they go and they support a colleague, and then the detriment is spotted. You can see it on the paper trail, but that's just an observation. Obviously, discrimination per se, the assertion that the facts, absent another explanation, then discrimination can be found, and drawing inferences and so on is the approach that is taken within discrimination cases. There's some caveats in relation to that about giving of false evidence and information and so on. But let's just come back into the context of housing again, because I would suggest that as housing practitioners, with the representation of tenants on the day-to-day, weekly practice that we have, we see harassment, and indeed harassment that's associated with protected characteristics within the context of what we deal with. Okay, so whether it's a without notice or return or of an injunction, so representing somebody accused of nuisance or annoyance to get to the threshold within the relevant test in section 1 of the Antisocial Behaviour Crime and Policing Act, it will fall in very quickly, nuisance and annoyance, and similarly in possession proceedings to a contract of the tenancy agreement will have examples of nuisance and annoyance, and of course it will rightly encompass all manner of specific and targeted behaviour on protected characteristics. Again, with enclosure notices and orders, not just crack houses, so to speak, or indeed a takeaway under lockdown, a van that I think Jim was dealing with earlier during the COVID pandemic. And then, of course, we see it in relation to the aspect of community remedies within that Act and antisocial behaviour case reviews. And there's another point just in passing to say, well, if that's exhausted, as I would suggest you can use PSCD claim and assert the issue that Daniel had talked about about not actually paying attention and giving due regard to harassment, if that's the context that we're looking in, that a tenant has been harassed by somebody else on a protected characteristic, and indeed there's inertia, or nothing's been done that they're satisfied with, and they've exhausted that process. It's non-exhausted, just thinking of the context of tenants' rights and being at the coalface in the county courts in particular. Let's just think about the context of unlawful eviction, running the claims in contract and tort, breach of quiet enjoyment, of course, trespass to land, trespass to person, goods, interference, pleading the tortious claim to then as the way in to be able to argue, for example, indeed aggravated damages. Protection from Harassment Act often features within those cases, and harassment has its own definition within that act, a course of conduct, one or at least two occasions, and indeed the civil and criminal recourse in relation to that. But in terms of the Equality Act 2010 and remedy, if it's established, is it something that we have thought of running? If we think of the complex, the factual nexus that we see in unlawful eviction, how might we use the Act to bring in a separate and a discrete aspect? Okay, because the Protection from Harassment Act might be the classic course of conduct of a thuggish landlord, but it's not specifically articulated in relation to protected characteristics. And so I wanted us just to think a little bit about that, and to think about the scenarios in which redress may be sought. And the sections on premises are set out in 33, 34 and 35. Disposal, so for somebody who has the right to dispose of premises must not discriminate against another. And then it goes on to say, here we go, at 1.3, a person who has the right to dispose of premises must not, in connection with anything done, harass the person who occupies them or a person who applies for them. And then looking down at 6, in the application of section 26, so that's the harassment clause. The following is not a relevant protected characteristic, religion or belief or sexual orientation. Neither of those. And similarly in section 34, we see that same provision at 34.4, and we sort of a bit of discussion between us earlier about that why the genesis of that. We're looking at harassment. It's very specific type of behaviour that's covered within the Act, but there it is in 34. And similarly in the management, the section that we use in particular in relation to occupying of premises, making use of benefits by evicting or subjecting to any other detriment, and there in 35.2, a person who manages premises must not, in relation to the management, harass the person who occupies them or a person who applies for them, and there's the exception once again at the end of the section. Another section of the Act, relationships that have ended. So a person mustn't discriminate, and then 182, must not harass another person if the harassment arises out of or is closely connected to the relationship that used to exist between them. And the conduct constitutes harassment as it would occur during the relationship. So going to pick up thinking of the unlawful eviction, interference with goods and so on, arranging after the lockout has long happened and the possessions are still being held, and there's an example of discrimination or harassment that would have that's asserted and happens and occurs, and if it happened by the landlord during the relationship when it was live as a legal relationship, then that will be caught. And then also on to liability of employers and principals. Anything done by person A in the course of A's employment is treated as being done by the employer. Anything done by an agent for a principal with the authority of the principal must be treated as being done by the principal. It doesn't matter whether the thing is being done with the the principal's knowledge or approval. In terms of an employer, section 1094, then it's a defence for an employer to say that reasonable steps were taken to prevent that. And so the example in the explanatory notes within the Act that is provided is that if an agent goes on behalf of a landlord to collect rent and is racially abusive, then it may well be that there is a claim then and liability lands against the employer, as well indeed as the agent, because the liability of an employee is an agent's 110 is set out, 110 is set out there. And thinking back to the employment tribunal type scenario, the situation of reasonable steps defence. So actually an employer will be cited, an employee be cited as well as the employer as discrete and may actually have separate representation in the employment context on the reasonable steps aspect, but actually a claim against the agent standing alone. So unlawful eviction, let's think of that example again, where you have somebody sent down by the landlord to help with the bouncing out of the tenant and the packing up of their possessions and so on. And then this harassment of the nature is set down and satisfying the test within the provision earlier on, then that's a claim that can be brought within the scenario, like the ball of wool, if you like, of who is doing what, who's the agent, and are they under the control in the course of employment, perhaps. Third-party harassment is a very interesting area, and I think it's important to cover this and to start to think more creatively, perhaps going forward, where next and so on. The good law really case that actually stands was brought into the old to the Race Relations Act 1976, and the test in that act was on grounds of race rather than the capturing, so to speak, of the related to. So historically, associative discrimination had to be fought out in the ECJ, and then it came back down, but actually it's covered. So the associative aspect now is wider than related to, but it's on grounds of race, of this case, where an employee was subject to racial abuse by an employee of another company operating in the environment in which Ms. Conti worked, and the claimant asserted a failure to take appropriate steps by her employer, that this had created an environment that amounted to harassment. Okay, so somebody else is doing the crude harassment, if you like, in this individual going to a parking type lot, type of scenario is what the facts of the case were. But actually the failure to take steps, the argument was put that and raised that was creating an environment amounting to harassment. And indeed, unwanted conduct, so going right back to that definition of harassment, can include inaction. Okay, so that's very important. But the matter of the inaction must have been taken place. This is under the RORA, but we'll see in a moment that it applies to the Equality Act in relation to, on the grounds of race. So the inaction must have been a discriminatory, well, it must have been an act which actually was on the grounds of race in that case. Okay, there wasn't another explanation, and that needs to be scrutinised on the facts of it itself. I think third-party harassment, the case of Burton and Rule, is perhaps the most well-known example, for all the wrong reasons, I suppose. The scenario of waitresses in a hotel going to serve while Bernard Manning was on the stage doing his turn. And this is some years ago, 20 plus years ago, and telling the management what was happening because the employees involved were being abused, and they went back in and out of the restaurant, if you like, or the social arena where the comedian was. And that's an example where there was no close relationship between the person doing the harassment, but actually the third party aspect, and the claim was argued against the women's employer. Unite the Union and NAILARD is the case, and it's useful, but I'd encourage people to read Conte and Unite the Union and NAILARD, and to just go through, because it breaks down matters of principal and agent, and in the peculiar context, if you like, of trade union workplaces and structures. The case in here was that the full-time official had raised questions of sexual harassment against two lay elected officers, so the branch elected officers who nevertheless were full-timers on facilities agreement and so on. And the claim was brought against the union for those actions that, in addition of the elected officers, but also that the failure of the employed officials of her was harassment within Section 26. And again, the question were on the second bullet here, related to sex, and that was a matter of fact of whether the inaction, which is capable of being unwanted conduct, of creating a harassing environment that is demeaning and degrading, and to use the language of the statute, it must have been related to sex itself, rather than say, well, actually, they're just shambolic the way they investigate things, or people were off sick, and so on. It has to be related to sex. Interesting just coverage to see the thought process of the Court of Appeal in that case, and indeed the EAT as well, and the ET. Liability for the actions of lay officials, so it was run in relation to principal agent and as against a third party, so confirmed within 109(2). Just thinking back to practical scenarios again, and to think of a practical practice in on the week and daily basis, if you like. It's a scenario that I'm just looking at the moment. So we've got a local authority tenant. A key is required to a communal area in a block of flats in which the tenant lives. Another tenant requires access to that area to read a meter. For some reason, the local authority, which I haven't worked out yet, the tenant holds the key. And when the other tenant wants to go into that communal area to read the meter, the key holder is subject to unwanted racial behaviour when that tenant wants access. So how might that then start to be looked at and considered in relation to the Equality Act? Think of the concept of third party harassment, the actions of a third party. But if it was to get anywhere, if it were to be able to be argued, then it would have to be shown that the local authority was lax on the basis, in this case, of a protected characteristic of race. So that's an example of the principle, I would say, just to start to think in a fertile way about what matters may be advanced. Okay, there may be a PHA claim against that tenant if it's a course of conduct, because every month, when the meter is read, then that's what happens. It's a course of conduct. And I just wanted to finally, just to finish up, to make reference to an old case, but an important case, which people, I think, probably will remember, either from seeing the news bulletins, because it was a case that went on for a long time, and that was Hussein versus Lancaster City Council, who facts were an Aden shopkeeper on an estate in which there was a dreadful scenario and ongoing, long-standing racist discrimination, racist harassment of the shop and so on. Now, this is back in the 1990s, and I would guess, I would suggest that the antisocial behaviour injunction legislation would capture this. But what had happened was that Mr. Hussein had to argue the case in terms of negligence and nuisance, and they failed. It failed in relation to the details, the nuances, and the permutations, if you like, of facts around nuisance and negligence. But actually, if that complaint had been made, if a community trigger had been used, but actually failing to take any action under the wider injunctive relief provisions, are we into this scenario where the local authority is actually facilitating the conduct if it's on the grounds of race, or its inaction can be attributed and gets home on the evidence? I think that's a discussion. I think that in what's been looked at with the Equality Act, as it's been set out and looking at those provisions, I'd be interested to have that discussion further with people, because the Equality Act is there, the antisocial behaviour provisions are there too. And I think we need to think creatively, and also separate remedy. Let's just think back to the unlawful eviction scenario, where you might say, well, it was pretty unpleasant. Aggravated damages, it was trespass to land. They actually, they went into the house and turfed all the stuff out. But as a separate remedy for injury to feelings as the remedy, and then grading that on the facts within the principles at work for damages that are well rehearsed and well laid down. So let's not miss the opportunity to use this act in a creative manner when we're dealing with housing. Okay, thanks.
Well, thanks so much, both Dan and John, for walking us through some of the sort of the edges and the boundaries of the Equality Act and what we might be doing with it in the housing law context. I see that there hasn't been a brave soul to ask a question aside from the standard, will the slides be available? And I understand that they will be circulated to attendees who've signed up in due course. So you will have the value of the excellent resource with all the case references sent to you. But I'm still nevertheless somewhat hopeful in the last few minutes of the session. Just looking at the time now, we have 6 whole minutes blocked out to see whether there is anybody who have, it needn't be a question, perhaps you have some experience yourself in a case of trying to use the Equality Act in a creative way in the housing arena, or you had a case where it occurred to you it might be possible to frame an argument, but you weren't sure quite if it would work. If there's anything like that that you would like to discuss or share with the panelists and with those of us here attending, I'm sure we'd be very grateful. So I stare hopefully at the little Q&A box and see if a notification pops up. Otherwise, I don't know if Dan or John, in terms of each other's presentations, had any kind of comments arising. So whether John had any comments arising in relation to indirect discrimination, or Dan in relation to third-party harassment and victimisation. That might be a bit harsh to put you on the spot there, but any thoughts?
I think it was Dan had mentioned, he said, in effect, I think, and correct me if I'm wrong, that to run the indirect discrimination, it's not just something you throw in. You need to have actually really sort of put the scrutiny in to run it, because if we're into new areas, I think that's more or less, I think, what you were saying, damage.
No, I think that's right, and I think it's, although, I mean, the reason why I started with the slide recapping the principles is although probably everybody's quite familiar with them, in a way, it certainly helps me whenever thinking about a new case like this to go back to it and take it step by step and say, to ask, what is the evidence that's going to prove this point? What's the evidence that's going to prove this point? And really, particularly in relation to comparator pools and comparative situations, I think that's an area which is can be particularly tricky and is worth paying some attention to.
We do have a question.
Okay.
I think we also have another one popping up in the chat. So I don't know if perhaps the panelists could read the question that's in the Q&A box about equality.
So the question that's come in from somebody is, are the PSED defences in police-led ASB cases that led to or caused harassment or victimisation? So John, I think this is primarily one for you.
Right. Just let me have a look on it. So are there?
There's probably a question there for you, Dan, if you can open the chat function.
Yeah, let me just find it.
I think that the
maybe for the benefit of those, I don't know if everybody can see the question answer. So before you go, John, I'll just read the question out. So the question is, are there public sector equality duty defences and police-led antisocial behaviour cases that led to or caused harassment or victimisation?
So well, in that case, the body, the police, would have to be in action to have contributed to an unwanted conduct, say, of the harassing behaviour. In terms of the PSED defence, well, the PSED aspect, that would be, again, just into due regard in relation to considering the various threads within what's required. I think that's all I can say on relation to that. It seems as.
So I'm just looking. I've found in the chat function the question that's been raised here is, outside of direct discrimination, what's your view on relying on heads of discrimination (brackets indirect discrimination, discrimination arising from disability) against an associated person of the tenant, e.g. their disabled child, and the impact is on them, or the rent arrears arose due to causes related to the child? I mean, I think here the key is exactly which, I mean, you need to look at the definition of the particular type of discrimination that you're relying upon, and then the particular section under Part 4 of the Act, the sphere of application, if you like. So, for example, in relation to indirect discrimination, the definition says that a person discriminates against another, brackets B, if A applies to B a PCP, which is discriminatory in relation to a relevant protected characteristic of B's. So it's clear that the protected characteristic has to belong to B. And so then the question is, who can be B, if that makes sense, when you look at Part 4. So, for example, in relation to disposals, you've got Section 33(1), a person A who has the right to dispose of premises must not discriminate against B, for example, by not disposing of the premises to B. That is not a situation in which you could run an indirect discrimination argument on the basis of a characteristic of B's child, because there isn't a question of there being disposal of premises to the child. The disposal of the premises or not is to the child's parent. However, if you look at Section 35, management, a person who manages premises must not discriminate against B who occupies the premises by subjecting B to any other detriment. And it seems to me that there may well be there may well be scope for arguing there that a detriment that the tenant is being subjected to is also a detriment to which their child is being subjected. I mean, the interesting question that arises there, I mean, particularly given that primarily we'll be looking at these things in the context of eviction, and I have to say I don't know the answer off the top of my head, is that 35(1)(b), A, must not discriminate by evicting B or taking steps for the purposes of securing B's eviction. Given that a possession order operates against all occupiers of a property, is a landlord who seeks possession of premises in which a child resides seeking evicting the child or taking steps for the purposes of securing the child's eviction under 35(1)(b). It seems to me on the face of it, my kind of initial instinct is that there's certainly an argument to that effect, but I have to say it's not something I've given detailed consideration to yet. So I hope that goes some way to at least setting out the approach by which the question might be taken. I don't know if John, or Alice, you've got anything to add on that.
No, I think you're right that as with anything, going back to the test and breaking it down and going through the legislative language is always very helpful, particularly with indirect discrimination, because you get that detail about precisely who A and B are and what their role is under each of the particular kind of headings. And so I think that's a very sensible approach, and I can't really add anything beyond that.
It may be, in fact, that there's, although I mean the difficulty, as I say, is that there's no code of practice in relation to premises, and that's the kind of question that you might expect would be answered in the code of practice, which is 10 years and counting. But it may be, for example, that some of the stuff in the public function and services code on what constitutes detriment might be helpful when you're considering those questions.
Great, well, thanks, Dan. Are there any other sort of final comments from either of you, John or Dan? I think we've had two excellent questions, and we've probably exhausted the faculties of everybody on a Monday afternoon. Anything further arising? Not really, other than to kind of reiterate the theme of this session and of the session that's to come, which is that the Equality Act has done a huge amount. I think if you look where we were before the Act came in, the problem with Lewisham and Malcolm that Section 15 was designed to address, the Equality Act has provided an incredibly useful set of tools, only some of which we've got used to using, but there seems to be a lot more in it, and a lot more than we're using. And particularly, I think what's interesting in Chambers, having colleagues who are working across different areas, is that you see that what is very well established in housing, say, might be slightly different to what's established in a police context or in an employment context. And I think it's always good to be kind of looking out for how it's being used elsewhere, how it might be used further in housing.
I think also that I remember observing it with the old DDA, in the sense of it was a few years before the housing provisions were used in the DDA. The sort of first cases like Brazier that came up in Romano. The DDA was 1995. If you look at the years of those cases, by the time it was getting into the higher court, there was quite a gap of a few years. So the statute is 10 years young, if you like. And there are these details, and we have to go through and remind ourselves, well, is it really excluding sexual orientation and religion and belief? It's like, well, yes, there's a lot in the Act, and there are areas and threads that can be picked up and used. So it's a fertile area, as Dan has said. And so, yeah, just make that observation, really.
Great, well, thank you both. So on that note, do join us for the next session with Sarah Steinhardt, Zia Nabi and Ben Chatway, who will be talking about positive action in the housing context, and almost certainly the most recent Supreme Court decision in that context, the Agudas and Hackney case. And in addition, there'll be a section on discrimination and homelessness, and how, again, we might be using the Equality Act more effectively to advance the interests of our clients. But otherwise, thank you for attending this afternoon. It's been a pleasure to not be able to see or hear you, but we can see the numbers at the bottom. So thank you for joining us. Cheers.